a physical phenomena or an abstract idea or a law of nature is not patentable, eligible subject matter. But that gray zone, Michelle, in between those two is the real battleground now, and that is where I think we're going to see considerable certainty over the next couple of years.
I agree, and the court didn't offer any guidelines in that respect, and they also didn't even say why they considered Bilski's claim. They found it to be abstract, but didn't provide any reasoning as to why it would be abstract.
Well, let me ask you this. As someone who was following this case from the very beginning and who's dealt with many, many inventions of this type and many software inventions and diagnostic method inventions, why do you think the Supreme Court ruled that this claim was too abstract?
I think because the scope of this claim is so broad. If you look at the claim, and I'm going to put the claim up here one more time, if you look at the claim, it's not really limited to anything. It's a series of transactions identifying participants, and then another series of transactions. And there's no specificity. It's really generic, and I think it's just not concrete. And what they were really looking for is, can this be written in a language that is a little bit more concrete and understandable so that someone looks at it and knows exactly what it's covering? I think it's possible. This just doesn't do it.
Well, it's interesting, Michelle, as you may recall from the oral argument, Chief Justice Roberts, when he was engaged in dialogue with the attorney for Bilski, stated, quote, "Well, but your claim one, it seems to me, is classic commodity hedging that has been going on for centuries." Mm-hmm. Well, that doesn't make it abstract. That means that it's been anticipated and that it's obvious. So the question, I guess, is, did they conflate, anticipation and obviousness with patent eligibility, in effect, in ruling that this claim was not statutory?
It's interesting. I think there is a little bit of overlap there. One way to look at it, Section 101 essentially asks, what is it? What are you claiming? And it's impossible to answer that question without identifying what is the scope of this claim. What is, from a written description perspective even, what are the bounds? What do the words mean? What is the invention? And so I think there is some overlap, and the court does look to that as a little bit of overlap for their decision.
Well, like I said, it's going to be interesting to see how a test evolves, if there is one, that or be an additional test to the machine or transformation test that will go to the very issue of abstract idea. Mm-hmm. I think a physical phenomena or a law of nature is pretty discernible, but an abstract idea often is in the eye of the beholder. And I think that now Chief Judge Rader called it right in the original Bilski decision at the Federal Circuit when he said it was an abstract idea, mm-hmm. but essentially did not adopt the sole test approach. And it turns out that he almost called it as to what the Supreme Court ultimately did. And now that he's the Chief Judge of the Federal Circuit, Michelle, do you think he is going to push forward with some kind of articulated test that would be an additional test or a second test or a third test? And if there are multiple tests, how do they fit together?
Well, it's interesting. I think the Federal Circuit has received a slap on the hand time and again for coming up with bright-line tests with bright-line rules. And this decision certainly is along those lines of not wanting a bright-line test. At the same time, the court seemed to leave open the possibility for the Federal Circuit to, for example, create a class of patent claims by their nature are considered abstract. They might label these business methods, but the court actually appeared to suggest to the Federal Circuit, you know, it's possible to come up with a set of boundaries and a definition for a specific class of patents that can just categorically be ruled out as abstract. Notice they didn't say that it was, you know, categorically all business method patents should be considered non-patent eligible, but they said that there is leeway if specific boundaries are given for the Federal Circuit to do that. And that moves us, we can actually go to our our next slide is so another point of interest that was raised in this case is whether or not is the court actually distinguished processes as an independent statutory class separate from the other classes of matter. So there are 4 classes of matter called out by the patent laws: process, machine, manufacture, composition of matter. And for these 4 classes, the later 3 are typically treated separately, but the machine or transformation test tied the first class of matter into the other statutory classes. So they said that a patent-eligible method needed to be tied to a particular machine, for example, if it was not transformative in nature. Rob, as someone else who has been practicing for many years, we've seen rejections in the past where system claims, in the past couple of years, system claims have been rejected using the machine or transformation test. Do you think that specifically calling a process out as its own independent class will put an end to these types of rejections?
No, I don't. I would like, as someone who thinks that everything can be represented as some type of abstract construct. Mm-hmm. If you think about it, practically everything in the world can be represented mathematically or from the perspective of a database file or a set of measurements or whatever. So the idea that something can be represented mathematically or that there can be a overarching operation description or flow of information description as characterizing what the invention is the real issue. And whether it's implemented as a system or claimed as a system or claimed as a method, my experience is that it's almost form over function. For example, if you look at many algorithms, they can be implemented in the form of a discrete system or a circuit or a semiconductor device. Or maybe they could be a programmable system where it has been fully programmed to perform that function. Or perhaps it could be software that's implemented on a general purpose computer. So my question to you is, are software inventions where you don't tie it specifically to the hardware? What is the implication of this decision in terms of the dicta, if you will, in the decision on whether or not software functionality is patent-eligible subject matter either as a method or as a system?
I agree that that distinguishing between methods and systems is probably form over function. From a software perspective, the fact that it no longer has to be tied to a particular machine or apparatus, software was generally not considered transformative in nature, and in a lot of respects, in some cases that's certainly the case, but for the most part, software claims were dealt with under the first prong of the machine or transformation test, whether or not it was tied to a specific machine. I think the removal of that as a requirement, software patent owners are probably very happy